Lesson: Key privacy laws impacting AI. The intersection of artificial intelligence and privacy law represents a critical area for compliance and ethical auditing. Two major privacy laws significantly impacting AI development and deployment are the General Data Protection Regulation of the European Union and the California Consumer Privacy Act of the United States. These laws establish frameworks for data protection, emphasizing transparency, accountability, and user rights, which are crucial for AI systems that rely heavily on data. Understanding and implementing these laws into AI practices not only ensures compliance, but also fosters trust and ethical standards in AI technology. GDPR, enacted in May 2018, is a comprehensive data protection regulation that applies to organizations within the EU and those outside the EU that offer goods or services to individuals in the EU. This regulation has profound implications for AI because it empowers individuals with rights over their personal data and imposes strict obligations on data controllers and processors. One of the key aspects of GDPR is the principle of data minimization, which requires that personal data collected must be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. AI systems, often requiring vast amounts of data to train complex models, must integrate mechanisms to adhere to this principle, ensuring they collect only the data strictly necessary for their intended purpose. GDPR also mandates that data subjects have the right to obtain an explanation of the logic involved in any automated processing that significantly affects them. This requirement introduces the need for AI systems to be interpretable and transparent, posing significant challenges given the often opaque nature of AI models, especially deep learning. To address this, organizations can adopt frameworks such as the AI Explainability 360 Toolkit, which provides a set of algorithms to help interpret and explain model predictions. By integrating such tools, compliance officers can ensure that AI systems meet GDPR transparency requirements, providing users with understandable explanations of AI decisions. Additionally, GDPR emphasizes the right to data portability, allowing individuals to receive their personal data in a structured, commonly used, and machine-readable format, and to transfer that data to another controller. This right necessitates that AI systems are designed with interoperability in mind, ensuring data can be easily transferred without compatibility issues. Implementing data portability can be achieved through the use of standardized data formats and APIs, facilitating seamless data transfer while maintaining compliance. The CCPA, effective from January 2020, introduces similar yet distinct requirements for data protection in California. While GDPR focuses broadly on data protection, CCPA specifically targets the sale of personal information, granting consumers the right to know what personal data is being collected, to whom it is being sold, and the ability to opt out of such sales. This provision impacts AI systems that may rely on data sharing and third-party data sources for model enhancement. To comply, organizations can implement consent management platforms that not only manage user consent dynamically, but also provide transparency about data usage practices. These platforms can automate the process of obtaining, recording, and respecting user preferences, ensuring compliance with CCPA's consumer rights. One of the practical challenges under CCPA is responding to consumer data requests, which require organizations to disclose and delete personal information upon request. This requirement necessitates robust data management practices, including the ability to efficiently locate and remove data. Implementing a data inventory and mapping system can facilitate this process, providing a comprehensive view of data flows within an organization. This system should be updated regularly to reflect changes in data practices, ensuring accuracy in responding to CDRs. A critical difference between GDPR and CCPA lies in their scope and enforcement. GDPR applies to all data controllers and processors dealing with EU residents' data, regardless of their location, with potential fines reaching up to 4% of annual global turnover for non-compliance. CCPA, enforced by the California Attorney General, imposes fines up to $7,500 per violation. Despite these differences, both regulations underscore the importance of data protection and privacy, driving organizations to reassess their data practices and implement privacy by design principles. This approach involves embedding privacy into the design and operation of IT systems, networked infrastructure, and business practices, ensuring that privacy considerations are integral to the entire data lifecycle. To operationalize privacy by design in AI, organizations can adopt the Privacy Impact Assessment Framework. This framework involves conducting a thorough analysis of how personal data is collected, stored, and processed within an AI system, identifying potential privacy risks and implementing measures to mitigate them. A PIA should be conducted at the early stages of AI development and revisited regularly to address evolving privacy concerns and regulatory changes. By systematically evaluating privacy risks, organizations can ensure their AI systems comply with both GDPR and CCPA while also enhancing user trust and safeguarding their reputation. Case studies provide valuable insights into the practical application of these privacy laws in AI contexts. For instance, the enforcement action against Google by the French Data Protection Authority under GDPR serves as a cautionary tale. Google was fined €50 million for lack of transparency, inadequate information, and lack of valid consent regarding personalized ads. This case highlights the necessity for clear user consent and accessible privacy notices, essential components for compliance. Organizations can implement user-friendly privacy dashboards, allowing users to easily understand and manage their data preferences, thereby meeting regulatory transparency requirements. Similarly, the CCPA-driven enforcement action against Sephora in 2022 underscores the importance of compliance with data sale provisions. Sephora was fined $1.2 million for failing to disclose that it was selling consumer data and for not honoring opt-out requests. This case emphasizes the need for businesses to clearly define and communicate their data sharing practices and to respect consumer choices regarding data sales. Implementing comprehensive data governance frameworks, which include regular audits and employee training on data privacy, can aid organizations in maintaining compliance and avoiding similar pitfalls. Ultimately, navigating the complexities of GDPR and CCPA in the context of AI requires a proactive and strategic approach. Organizations must invest in building robust data governance structures, integrating privacy-enhancing technologies, and fostering a culture of compliance and ethics. By leveraging practical tools and frameworks such as AI Explainability 360, consent management platforms, and privacy impact assessments, professionals can effectively address the challenges posed by these regulations. Moreover, continuous monitoring and adaptation to legal developments are essential to maintain compliance in a rapidly evolving regulatory landscape. Through these efforts, organizations can not only mitigate legal risks, but also build consumer trust and uphold ethical standards in their AI endeavors.